Hi, welcome to my channel and please don't forget to like, comment and subscribe. Today I bring a topic about the carrier's liability for delay under UAE maritime law. One of the most complex legal issues in the carriage of goods by sea in carrier's liability and its limitations. Carrier's liability regulations are different from one regime of law to another. Under common law, a carrier was considered a bailee who would be liable unless he was able to prove that damage or loss was attributable to certain expected causes. Where the principle of freedom of contract governed the carriage of goods contract, opening the door for abuse by the carrier of his bargaining position. In contrast, under civil law, a contract of carriage was considered a kind of contract for the hiring of services where carrier's liability was based on the principle of presumed liability. Due to globalization and gradual global integration, it became important to have a unified system which regulates the carriage of goods by sea and creates a balance between couriers and shippers. As a result, international parties gathered in Brussels in 1924 to agree on the first convention unifying certain rules related to maritime carriage. Ratifying the international conventions on the carriage of goods by sea would result in unifying the rules of the applicable to such carriage and, in particular, the concept of limitation of carrier's liability. The importance of having clear and unified sets of rules regarding carrier's liability is highly desired in maritime capitals around the world. The United Arab Emirates, or UAE, a regional hub for maritime services, is considered to hold a strong position as a maritime shipping center. According to the 2019 report by Menon and DNVGL on the leading maritime capitals of the world. The largest port after that in Asia for handling containers is found in the UAE. More importantly, the 2019 report states that Dubai plays a role as a transit hub strategically located in the middle of Europe and Asia. Moreover, the UAE was ranked fourth of the ports and logistics by the leading maritime nations of the world on 2018 report by Menon Economics and DNVGL. The importance of the maritime industry in the UAE has led to the establishment of the Emirates Maritime Arbitration Center in 2016 to assist settling maritime disputes in cost-effective way. Due to the importance of the UAE in the maritime world, this will analyze the rules governing carriers' liability in case of delay in delivering the cargo under the UAE laws, aiming to compare them with those of international conventions. Also, it is worth noting that the UAE has not to date ratified any of the international conventions pertaining to the carriage of goods by sea. The carriage of goods by sea in the UAE is at the present governed, in principle, by the country's federal law number 26/1981. The Commercial Maritime Law, or CML, the inability of the present CML to solve emerging issues, and the desire of the legislator to implement the latest international maritime conventions have led to the drafting of the new maritime law, not yet in force. The new draft law is called Maritime Law or ML instead of Commercial Maritime Law in order to cover all maritime related issues. The drafters recognized that the present law has become outdated and incapable of resolving present complicated maritime issues and also problems. Therefore, the new law seeks to codify those rules set forth in the maritime related conventions. Among other amendments, the new draft tends to avoid lengthy procedures under the present law by shortening the periods for required notices and the time limitation of filing lawsuits. In addition to the UAE CML, the Convention on the Multimodal Transport of Goods between the Arab States or the Arab Convention would apply as a matter of law if a contract for the carriage of goods involves sea and other modes of transportation. Therefore, if the movement of goods requires carriage slowly by sea, the Arab Convention does not apply. Where any conflict between provisions of the CML and the Arab Convention arises in the UAE context, the Arab Convention would prevail by virtue of the application of Article 8 of the UAE CML. The CML of the UAE sets out several provisions regulating cases of delayed goods delivery during the carriage of goods by sea. Before the provisions related to delay in delivery are discussed, it is worth noting that, unlike the Hamburg Rules, neither the CML nor the Arab Conventions explicitly require the date of delivery to be specified in the Bill of Lading. In the Hamburg Rules, Article 15, Rule 1 states that the Bill of Lading must include, inter alia, the following particulars: the date or the period of delivery of the goods at the port of discharge if expressly agreed upon between parties, making inclusion of the date or period of delivery in the Bill of Lading obligatory. So thank you for watching, and don't forget to like, comment, and subscribe.